Assalamualaikum and greetings we beat to Dr. Khairil. So we are from the group of Tengku Maimun CJ and we will be presenting on checks and balances by the legislature in Malaysia. So the presentation today will go as follows. Firstly, I, NAJYA, will be introducing the question. Secondly, Sister SYAHIRAH will be explaining checks and balances on the side of legislature towards the executive. Thirdly, Sister Nuha will be explaining checks and balances on the side of legislature towards the judiciary. And lastly, I will conclude the discussion for today. Our question reads, the doctrine of separation of powers in the Federal Constitution requires the legislature to check the executive and the judiciary. Explain how the legislature checks and balances the power of the executive and the judiciary in Malaysia by referring to decided cases and relevant provisions of the Constitution and laws. So next, let's start with the important concepts to tackle the question. So first and foremost, it is important to understand that Malaysia has a unique form of government in which it practices parliamentary democracy and also constitutional monarchy. So Malaysia follows the Westminster model, where there is a PM, the Prime Minister, and the Prime Minister acts as the head of the government and he will pick his own cabinet that will exercise the executive function of the government. So the Prime Minister is directly answerable to the legislature. In our system, the head of state is a monarch bound by the constitution, which is in line with the constitutional monarchy system. So next concept is the doctrine of separation of power, in which this doctrine aims to fully separate the organs of government into three. Firstly, the legislature, the legislative body, which is the one that is responsible to make laws. Secondly, the executive body, which is the one that governs and enforces the law. And lastly, the judiciary body, which is the one that applies the law that was made by the legislative. So this principle includes separation of institutions and separation of functions between the institutions. So in simpler words, there should be no dual membership of the members of the mentioned organs. For example, a member of the executive, by right, should not also be the member of judiciary and carry out judicial powers. So he has to stick to the organ that he belongs to. From this doctrine, the principle of check and balance can be derived, in which every organ is given specific powers over the other branches to oversee their conduct. So in Malaysia, the legislative body is the parliament, which consists of the YDPA, yang di-Pertuan Agong, Dewan Negara and Dewan Rakyat. This is as in Article 44 of the Federal Constitution. The executive authority, on the other hand, is given to the Yang di-Pertuan Agong, exercisable by him or by the cabinet or any minister the cabinet authorizes or other persons the parliament may delegate its power to. This is as in Article 39 of the Federal Constitution. Article 121, on the other hand, establishes the superior courts, high courts, court of appeal and federal court to carry out the judicial functions. So, the last important concept is the concept of rule of law. So in this concept, no one is above the law, not even the government. Thus, the country, Malaysia, adopts the principle of check and balance, which complements the doctrine of separation of power to ensure that all these organs are free from unfairness. So all organs would, in turn, be conscious of their actions as they are aware that the other organs are looking over them as well. So this will ensure that we can uphold the rule of law, because all these organs will work hand in hand to ensure that they are doing their functions with responsibility and with integrity. So next, I pass the floor to Sister SYAHIRAH to further discuss the question.
Thank you very much, Sister NAJYA. My name is Nuha BALQIS and I would like to continue on the next part of this presentation. So we will be talking about the legislature, checks and balance towards the executive. So firstly, the separation of power in Malaysia is vested in the three main organs of the government, namely the legislative, the executive, as well as the judiciary, and all them derive their powers from the constitution. The legislative body consists of three components, including the YDPA, Dewan Negara, and Dewan Rakyat. The main functions of the legislative is to pass federal laws, make amendments to existing federal laws, examine the government's policies, approve the government's expenditures, approve the new taxes, and many more. On the other hand, the executive governs the country according to the laws made by the parliament. And in addition to that, the functions, jurisdictions, other than those provided for the legislative and judiciary shall be deemed to be under the power of executive functions. In the federal government, the executive consists of the Conference of Rulers, YDPA, the Prime Minister, the Cabinet, as well as public services. Although the judge in the case of public prosecutor and Kok Wah Kwan ruled that the doctrine of separations of powers in Malaysia is not expressly mentioned or is not a mere provision in the Malaysian Constitution, these doctrines remains as the spirit and soul of the Constitution in order to safeguard the organs of government from any abuse of power and centralization of authority. If the legislative branch or the parliament does not satisfy with the Prime Minister or the executive, members of the legislative can cast a vote of no confidence against him. A motion of no confidence is basically a vote that indicates a person is no longer deemed fit and has the majority support to hold the position, and these operations enables that the executive to become subservient to the legislative branch and thus avoid any abuse of power and ensure transparency, because every act done by the executive must be in accordance with the legislation. So this is further enshrined in Article 43 Clause 4 of the Federal Constitution, which mention if the Prime Minister ceases to command the confidence of the majority of the members of House of Representatives, then unless at his request of YDPA dissolve Parliament, the Prime Minister shall tender resignation of the Cabinet. By virtue of this provision, Prime Minister can be dismissed and removed if he ceases to command the confidence by way of resignation or YDPA resolve the Parliament. And this principle is also applicable at the state level, which further mentioned in Section 2 Clause 6 of the 8th Schedule. Due to this doctrine, if a vote of no confidence is passed in the Parliament, the Prime Minister is deemed to lose the support of the majority of the members and the government must responsible collectively, meaning to say the entire government must resign. However, what amounts to loss of confidence of the majority of the members of the House is nowhere defined. Hence, so long the majority, if the half plus one of the total membership of the House no longer has confidence in the executive, they shall no longer be in power. This practice can be further illustrated in the judgment of Abdul Qadir Sulaiman in the case of Tun Datuk Haji Mustafa bin Datuk Harun and Tun Datuk Haji Muhammad Adnan Robert yang di-Pertuan Negeri Sabah and Datuk Joseph Pairing Kitigan. In this case, Datuk Joseph Pairing Kitigan was appointed as the head of government but subsequently began to collapse in the wake of some defections of his assemblymen to the rival coalition. However, the state cabinet minister refused to follow the resignation of the chief minister. In this case, the court followed the judgment of Adik Benra and Akintola, in which the Privy Council held that there is no limitation as to the material by which lack of confidence should be assessed. What matters most is that if one who is in the position lost the confidence from his government, he must ought not to remain in his office. To further emphasize this principle, we could also observe from the Federal Court decision in the case of Datuk Sri Insinyur Haji Nizar Jamaluddin and Datuk Sri Dr. Zamri Abdul Qadir Nizar Jamaluddin, where in this case, the appellant sought the declaration that he was still the Menteri Besar of Perak, when actually His Royal Highness Sultan of Perak received 3 letters from the members claiming that they had lost confidence in the appellant, and the court held that the evidence from outside of the house, like statutory declarations from the MPs, can also be taken into consideration by His Majesty in determining whether there is loss of confidence. However, the most prominent factors is that the number must come from the majority. And it is safe to say that in the current practice of our legislation, if the legislative lost the confidence towards the executive, then they can table a motion of no confidence in the Parliament. In short, the collective responsibility and the power given to cast a vote of no confidence is vital in upholding the principle of parliamentary democracy as has been practiced by our country. Although we cannot observe a clear and total distinction of separation of powers among the legislative and the executive, because there are tendency to be overlapping between the person who are in the legislative and executive, and our practice is unlike other countries like United States of America. The current practice in Malaysia, however, disable any centralization of power on behalf of the executive, especially the Prime Minister. And interestingly, the vote of confidence on the other hand allows the Prime Minister to prove his moral legitimacy, which will impliedly help the executive pertaining to the administration and the governance of the country, like what has been passed in Parliament recently. And while vice versa, if it is proven that the Prime Minister no longer holds the trust from his own cabinets, then the position must be replaced to ensure political stability.
Moving on to the part where the legislature checks and balances the power of the judiciary. Firstly, it is material to note that Malaysia is a democratic country where the people's interest is the paramount consideration in arriving at such a verdict. Prior to the deliberation on the check and balance between legislature and judiciary, it shall be acknowledged on the establishment of the Malaysian judicial system, as per the antecedent of the United Kingdom judicial system, by which it is an unified judicial system founded on the British common law. Moving on, the power for the judiciary is as stipulated in the Federal Constitution, namely in Article 121, allocating the jurisdiction of the courts throughout the entire judicial system. On the basis of this doctrine, the endeavor to safeguard liberty and avoid abuse of power by check and balance basically so the three organs. Hence, the action of legislative check and balancing the judiciary can be seen in few circumstances. Into added amendment of the Constitution specifically in regards to the judicial power, as well as appointment and removal of judges. To commence, the permanent event to connote the check and balance by the legislature to the judiciary is in 1988, namely the amendment of Article 121+1 and the occurrence of judicial crisis. Initially, notwithstanding the doctrine of separation of power, the amendment has effectively denied the independence and laid down the limitation of interference made by the judiciary. The original provision stipulated that the power in judicial matters was specially and exclusively vested to the judiciary, respectively. Judicial power of the Federation shall be vested in two high courts, on the contrary to the amended version, whereby there shall be two high courts of coordinate jurisdiction and status that they shall have jurisdiction and powers as may be conferred by all under federal law. Based on the above, it is crystal clear that the deletion of the word vested has undermined the word of judiciary, as well as denoting the court institution is vulnerable to be interfered with by other organs, either by the government or non-government bodies. The lacuna in the law has colored their power to degree which urges the people to impugn the definite power of the judiciary. As a matter of fact, the amendment was made in subsequenting to the case of PP and Dr. Yapang, thereby discoursing on the contravention of power allocated in Section 418A of the Criminal Proceeding Code to Article 121 Clause 1, by which it states that, notwithstanding Section 417 and subject to Section 418B, the public prosecutor may, in any particular case triable by a criminal court subordinate to the High Court, issue a certificate specifying the High Court in which the proceedings are to be instituted or transferred, and requiring that the accused person be caused to appear or be produced before such High Court. The power of the public prosecutor under subsection 1 shall be exercised by him personally. The prosecution in the same case has initiated to transfer the case to other court and pursuant to the section mentioned above, whereby it grants the power to the prosecution counsel to discharge a judicial power. Similarly, in the case of Pendakwa Raya and Dato Sri Muhammad Najib bin Haji Abdul Razak, the court had acknowledged the unconstitutionality of Section 418A of the Criminal Proceeding Code, albeit, as we are depending on the doctrine of stare decisis, including the majority judgment as per Abdul Hamid. Including the majority judgment as per Abdul Muhammad, the case of BP and Cohort 1 concluded that, despite the amendment, the judiciary power remained and sustained. To elaborate, the case arises when the Court of Appeal held that the sentence for Section 97, subsection 2 of the Child Act 2001 is conferred by the YDPA for the convicted child charged under Section 302 of the Penal Code. The gist of section mentioned before is deemed to be contrary to the doctrine of separation of power on the basis of confiding the power vested by the court to the legislature. In addition, in the case of NAJYA, where in this case it involves the non-government body, where the court held that any discharge of judicial power made by anyone who is not a judge, nor a judicial officer, nor a governmental officer is an act of alter bias to Article 121. Nonetheless, is it actually possible to infer that the amendment has eliminated the check and balance of the two organs? Roughly speaking, it is heinous to say such a thing.
The amendment shall not be deemed to be inimical to the judiciary, rather a duty of the judiciary to uphold the Constitution, but has eventually impinged its power as well, impugning their capacity and power on such matters. The fact that Malaysia is a democracy contrarily considers the people as the significant factors in implementing such things, including any amendment of the Federal Constitution. Furthermore, it shall continually be reminded that the doctrine of separation has indicated the law by which the Constitution, as the supreme entity above all, infer that all the three organs and any people further understand is nothing higher than the Federal Constitution. Apart from the above, the constant police by legislation to the judiciary can be seen through the appointment and removal of judges pursuant to Article 122. And for that any appointment of the Superior Court judges need to be made ensuing to the consultation with the Prime Minister. To support the case in the court in the case of Dr. Sri Anwar Ibrahim and BP held that even if the YDPA disagrees or was bold in giving his advice, the Prime Minister can legally insist the YDPA to appoint the judge. And then additionally, the de facto case to support this is by the sacking of Tun Sani Abbas, the former Lord President, and the other three Supreme Court judges by the Prime Minister, which was Dr. MOHAMAD. As a matter of discussion, shall be known that the case emerges due to the challenge made by the position for the vote won by the omnibus election in conceding that the court might be in favour of the position. He then eliminates all the judges in fear of losing the truth. Hitherto, the case is reckoned to be a consequential one to the judiciary to not interfere with the legislature or else. On the other coin, as we are keeping with the status quo, in the recent news, it has been stated that Tunku Maimun Tuan Mat, the incumbent Chief Judge of Malaysia, voiced out her concern in upholding the judicial independence. She then elaborated that the appointment and removal of the judicial members should remain apolitical and free from any form of interference and influence. In relation to this matter, considering the heavy duty of the judiciary, any process occurring in this institution shall be inextricably within it. The intercession with other organs, though done in the name of check and balance, is still deemed to be encroaching and tampering with the judiciary system. Based on the above justification, it can be concluded that the only way for the legislation to check and balance the judiciary is through the process of appointment of
So in short, the legislative body may exercise the principle of check and balances on the executive, firstly by the status quo that requires the executive to be directly answerable to the legislature at the parliament. Secondly, the legislature can also table a motion of no confidence in order to force the Prime Minister to resign or to advise the Yang di-Pertuan Agong to dissolve the parliament. On the other hand, the legislature influences the judiciary as the Yang di-Pertuan Agong will appoint the judges on advice of the Prime Minister after consulting the Conference of Rulers. This allows the Prime Minister to pick judges that he is confident of to do their work. Secondly, the Prime Minister or the Chief Justice, after consulting with the Prime Minister, can also table a motion in the Parliament to send a request to the Yang di-Pertuan Agong to set up a tribunal to remove a certain judge, where there will be certain procedures to be followed. So, our opinion, we believe that the doctrine of separation of power is a very important doctrine in building a country that is free of bias, fair and just. We believe that humans are not free from making mistakes and sometimes might even lose their moral compass and act dishonestly, hence the need for another to always act as an overseer to them. Even from the Islamic perspective, it is mentioned in the Quran, Surah An-Nisa, verse 135, that people have to stand out firmly for justice, meaning that we should always fight against injustice. So this is why we believe that check and balance is important, so that members of one organ will constantly be in fear to commit any misconduct. Thus, we have three suggestions for today. Firstly, our suggestion is for the Federation to always adopt this doctrine and keep the current practices of check and balances as of now, as we believe that it is a good way to ensure that the organs of governments are working systematically and always conscious of the thought that their work is reviewed by another. Next, we also believe that the judiciary has to be independent, and an effective way to do so is by returning the phrase vested into high courts that used to be in Article 121 of the Federal Constitution as mentioned in the above point. We also agree with Tengku Maimun Sija's opinion that the judge's appointment should be free from the executive's interference, since we believe that this will ensure that there will be no potential bias or unfairness that might arise from the appointment. So with that, thank you very much, and never been prouder to present.